Welcome to the Extra Mile podcast for bar exam takers. There are no traffic jams along the extra mile when you're studying for your bar exam. And now your hosts, Jackson Mummy and Megan Saya from Celebration Bar Review.
All right. Hey, everybody. Welcome. It is Wednesday, February 9th. We are in the 2-week countdown to the bar exam. That's hard to believe, isn't it, Megan?
Yeah, it really is.
Listen, it's Super Bowl weekend for the whole world, but it's Irrational Weekend for bar takers. With this weekend coming up, Megan, we call it Irrational Weekend. How should people be thinking about this in terms of their studying? How do they keep their focus?
Yeah, I think you've got to keep your head down and keep doing what you've been doing. Don't try to restructure your entire study strategy this weekend. Don't make any rash decisions about how the bar is going or how your capabilities. Keep pushing forward. If you have a rough essay or a rough MBE, you need to shake it off and do another one. Okay. Don't stay there and determine all the past work that I've done is meaningless because clearly I'm useless and not going to be able to pass this, right? Positive self-talk is going to be really important over the next couple of weeks, and particularly when you hit these speed bumps that you will over the next couple of weeks. They're normal and natural, but you need to continue to talk to yourself the way you would talk to your child, the way you would talk to your spouse, to your best friend. You would not tell them that they're incapable or worthless. You would tell them you're doing a great job and I believe in you. And that's how you should be talking to yourself as well.
We're going to talk a little bit about that today. So we've got some things going on. We're glad to have all of you with us. As always, we've got Megan and June with me. We're going to be we've had a lot of questions that we're going to cover. And then Megan and I are going to do an explainer to talk about the Parol Evidence Rule. It's exciting stuff, isn't it, Megan?
Oh yeah. I'm enjoying this series and being able to go through some of these subtopics with you guys. So I hope they've been helpful.
Yeah, we're getting great feedback on them. And it's really, for me, and I think for you, Megan, it's really a good intellectual exercise. Sometimes we forget about some of these detail things and we get to dig in. And of course, I get to build more mind maps, and that's always fun. But we'll be sharing that with you in a few minutes.
All right, Jackson, I think we're going to jump right into the questions now because I know we've got a lot and I want to make sure we've got enough time to get into the Parol Evidence Rule discussion at the end. Let's go to it. There's been some changes with the MBE tests, MBE 1. Where can people find that test?
You're going to find it will be in a different numbered assignment depending on which course you're in. It's review MBE questions and take practice tests near the bottom of your assignments, obviously, or the bottom of your list. And you will see an assignment in there that's got the Multistate Bar Exam 1, MBE 1. That's the February 91 test. You'll also see a couple of lessons below that, something called, the Complete Practice Exam? Is that the name? That's the 2021
the 2021 comprehensive practice exam, I think it's called.
Comprehensive practice. Yeah, I think that's it. It's something. It's CPE, whatever that stands for. And we really want you to do those two tests. Now, one of the things that's helpful to us, and this is us asking a favor of you all. We don't know, Megan and her editors and I do not know if the CPE test is good, bad, or indifferent. It's never been used before. It was not an actual MBE. It was just a collection of questions that the National Conference put out, which is good. However, we don't know if it's got any predictive value at all. It could have a great predictive value or a very low predictability factor. So one of the ways that we can figure that out is if you report to us your score on MBE 1, which has a high predictive factor, and you give us your CPE score, we can see if there's a correlation between those two first. And then when the bar exam comes out, we'll see how you actually did. And we'll then triangulate those three. That sounds pretty wonky, doesn't it? And we'll look at all three of those scores and see how they're doing. And the more data points we've got, the more we can assess going forward. So you're donating your scores to science at least, so we can see what's going on. So make sure you do those and report the scores back.
Great. And in the meantime, how should people be viewing their raw score on that practice test?
Yeah, you and I talked about this. There's no scaling because it wasn't actually a multi-state. And remember, it's 200 questions and the actual MBE is based on 175. So there's no way to equate it from a scaling standpoint. So I think where you and I came out, Megan, is we just want to hear your raw score. Just give us the raw score. If you're getting 130 questions correct out of 200, I'd feel pretty good about that, wouldn't you?
Yeah, definitely. Definitely. So yeah, let's focus to, I really want to encourage people to focus on using it as a study aid. So going through, seeing how you're doing and seeing where you need to beef up your understanding. What are you missing? You can certainly use it to get a baseline for yourself just of, hey, how comfortable or uncomfortable should I be feeling about my MBEs as I'm practicing right now?
And the other part of this, to be clear, is you should take this test, this CPE, under test timed conditions. This is not a test that you do a question, look at an answer, or you do it over 3 days, or you stretch it out. I think when you use it that way, you're missing the point. If you want to do randomized question practice, we have an 800 question database in your course. It's in the course there, it's online, and you can do those 800 questions, and you could do 10 a day or 20 a day or whatever. But when you take this CPE, like the MBE one, you do it in 2 3-hour segments, unless you've got accommodations, in which case do it under the time frame that your accommodations would provide for you.
Perfect. All right. This person wants to know if there's a way to access past MBE exams that they took online and see how they scored.
Yeah, you can definitely do that. The application we use is called TestMoz. And if you put in a valid email, and some of you aren't doing that, we know, but if you're putting in a valid email, when you finish the actual bank of questions, whether it's 25 or 30 or 100, whatever it might be, the program will send you a score. And I could ask June about this, but I think what she'd say is if you haven't seen the score, it's probably because that email went into your spam folder or promotions folder. And if you've checked all of those things and you're positive that you actually finished the full set of questions, right? We have people that say, well, I did 95 out of 100. No, you got to do 100 or it doesn't think you're done. But if you've done all of that and you still can't find it, send an email to June. She can search the database, and if we've got a report, we'll send it out to you. So that's the best way to get a report from there. And then, of course, if you've entered your scores in the course platform, in the worksheets that we've given you at the end of some of these bigger tests, that material is being saved there, and you can go back and check your worksheets once you've entered that information.
The next is, will the MBE exam be on the computer or using a booklet?
As far as we know, the MBE will be done with a booklet being handed to you and a Scantron. You will not use your computer on day 2 of the bar exam. Now, this is the national conference. They've set it up their rules, their way. I suppose a state could try to do something different, but I don't see any state that said anything about computer entry for the MBE. So I'm assuming it's booklet, you do the Scantron. I would say that's also true in Florida for the Florida multiple choice, so Tuesday afternoon. But in all other jurisdictions, including the UBE on day 1, when you're doing essays and or performance tests, that will be a booklet handed to you, maybe scratch paper, I think scratch paper in most cases. And then you will actually type your answer on the computer and you will upload your answers to the examiners. That's my understanding.
I do just want to say, check with your jurisdiction, because it's not that they can't do it. It's not like an online test. It's you're in the room and everything. There have been past ones, like California did it online in 2020, like in the room, but on your laptop. So I actually just want to say, I think you should check with your individual jurisdiction and find out specifically. I believe this time California is doing it on a Scantron, but even that, I'm not 100%. And I certainly don't want to vouch for all jurisdictions. So you should check with your jurisdiction beforehand, which is just a general blanket. If you have a question about how Mississippi or Maine or Colorado or California or Georgia or Florida is doing a piece of the exam, you need to find that information out directly from them. We learn a lot about the bar exam, but we are not capable of keeping up with all of the various rules for every jurisdiction. And I would hate to tell people the wrong thing. So please check with your jurisdiction, find out what you can bring, what you can't bring, what times you need to be places, what materials you need to have with you, et cetera, because every jurisdiction has very intricate and different rules from the others, and they are all subject to change, right? exam, it feels like they have new rules that they amend or take away or add. So please be checking what the rules are in your jurisdiction for anything. Okay.
Yeah.
Okay. All right. Let's get into some study questions. Lots of really good ones this week. All right. I've resumed my study with my focus on the July UBE. Should we start meeting now regarding the essay coaching, or should I wait until closer to July, like April or?
Okay. And I think this applies to you, Megan, as well. I'm not taking July coaching calls for the next couple of weeks. All of my time goes to the February students. Once we get to March, however, I do want to start getting calls, and I don't want to wait till April or May. Do you?
No, absolutely not. I don't want anybody waiting. The best time to figure out how to pass the exam is as soon as you possibly can, and don't wait till some arbitrary date and then try to feel rushed or cramming, like you're cramming things in.
Yeah. And I would also say, if you haven't done the personal writing workshop with me and you're a July bar taker, I would try to schedule that in March with her, get that basis and foundation in early. I would also say it's a good time to do the time management training with Brianna and to do Calming the Chaos with June. That month is a great time to get those foundational pieces together. So you've got a schedule, you understand how to write, you've got a mindset approach. It could be a huge advantage to take that time in March to do that and get underway and then start moving towards July.
Great.
I can't believe we're talking about July already.
All right. Next is a question about photo reading. The student wants to know, how do I activate before I write an essay?
I love that question. How do you activate before you write an essay? The way that I do this and the way that I like to teach it is first read the essay question, just the whole question and the call of the question. Then use that as your intention and go ahead and photo read the relevant outlines. So just do a quick photo flip of the outlines, but the intention is I want to answer the following 3 questions or 4 questions from this essay. Then after you've done that, give yourself about 20 minutes to just incubate, just let it roll through, go do something, make a cup of coffee, walk the dog, whatever. Then sit down and start writing your essay. The writing of the essay is the activation of the photo reading that you just did with that intent. So the idea here is that you're actually using the practice of the question as the activation. You're not doing a mind map before you do it or anything else. You're letting the writing work for you. It's the same really as I'm going to sit down and do 25 questions in contracts, MBEs, photo read with the intention of answering the 25 questions without knowing what they are. Just, I want to get better at these, and then use the practice questions to activate. And then after you've done the question, essay or multiple choice, then start filling out your mind map with the information, the answer explanations.
Okay, wonderful. All right, the next question I can take, it's someone's asking, he said, I'm trying to self-grade my response to the specific Georgia evidence question essay. And they called it the model answer seems pretty insufficient. It's about 200 words, doesn't address some of what was asked. And then they have said they have the same issue with some other subjects. All right. So I looked it up to see exactly which one this was. Okay. So first is, and this comes up a lot, it's really common, it's not a model answer. So if it doesn't say model answer, that means it's not written by us or our editors. It's not FLA style. It's not the way we want you to write. If it just says answer to, it's generally those are provided by the examiners as a sample. Sometimes they come from actual responses that a student actually wrote under time conditions and they deemed it passing, which is pets, but they are not the way that we want you to write. So when you see, and I looked at this particular one, it's very old. I will say, I find that, and Jackson, tell me what you think. I find that when you go back to some of these older questions and answers, the questions are fine and helpful for figuring out what to say, but the answers, the standard for what is a passing essay has changed dramatically, in my opinion, over the last few decades. And 200, like the student is correct, writing 200 words where you don't even address everything that was in the question is not going to get you a passing score now. Whereas in 1995 in Georgia, that might have been sufficient.
If you could belt, we called them belchers. You just belched an answer out and went on.
Yeah. So just know that if you see something and you think, gosh, this is really short, it's not helpful, we include it only so that you can check things like, okay, what are some of the concerns, the conflicts that they wanted you to talk about? What are some of the black letter law? Sets you on the right path so that you're able to check. This next question, this person said they attempted the February 2018 MPT set to try and get some more MPT practice. The first one was simple, but the second one they had a really hard time with. And saw no clear tests, rules, or elements in the library. Said any advice for how to go about something like this if an MPT like this were to show up on the exam? So I know we've talked a little bit about the MPT work. For people who are taking the July or later exam, if you need specific help with your MPTs, I think the best way to go about it is to schedule hourly coaching or the full coaching with myself or with Jackson, because it's much easier, obviously, to walk you through MPTs and how to do it one-on-one when we have a dedicated 2 half-hour calls in order to do that. But in general, the advice that I would give with the MPT, so if you're in February and you're like, I don't have time, I've got a couple of weeks and I need to know what to do for the exam this time. In general, what I like to do is read the charging document and figure out what direction you want to go in. So figure out, you might not know it exactly, but just like reading the calls of the question, you have your general outline of where you need to be. And then from there, I actually usually suggest to people to go straight to the library rather than going through the file. Because just like if you're writing an essay, you get your conflicts, you get your calls of the question, you figure out what the conflicts are, if there's any hidden conflicts or foundational pieces. And then in your mind, what's important, because, oh, this particular conflict is dealing with consideration. So I know in general, even if you're not super sure of yourself, you're like, I know what consideration is. I know what that law is. I know what the standards are. And so then you can go through and pull out the facts that are applicable to whether or not there was consideration in this question. On the performance test, you don't know the law beforehand, right? You're not expected to, you don't have to, that's perfectly fine. So instead, what I tell people to do is go into the library and try and find those tests before you go through the file, because you just don't know what you're looking for yet at that point. So I know this person said there's no tests, there's no rules. I promise there are, right? There's never been a performance test where they don't give you that information. It's just that you have to practice how to find it. So get really comfortable with going through the cases, looking for lists, anything numbered, looking for quotations, looking for citations. Did they cite to another case? Okay, that's probably useful somehow in some way. How can I use this? Is there anything that they give you a standard for, right? Or does the court say, we'll see it a lot in performance tests, the court will say, here are the facts, and then they'll say of their particular case, and then they'll say, here's the standard that has been given, right, by the other, by maybe another court or in our jurisdiction. And then they either apply that standard or they say, but we disagree and we actually think here's the right standard. Either way, right, that's giving you your test. So if they, whatever test they're applying, that's showing you, here's the test that I'm going to apply in my situation. And so that's where you want to look for it. And certainly they often will give you black letter law as well. And that's really helpful. You might not use every single piece of it, but there's going to be at least one piece in there that's going to be important for you to pull out. And then you can go into the file and find the facts that help support the arguments on either side of those. So if I've got this 3-part test that I need to go through, then you'll be able to go through the file saying, all right, I'm looking for facts that are applicable to part 1, part 2, part 3. All right. I hope that's helpful. Okay. Next is actually a question that I think June, I'm going to have you jump on and answer. If you get a chance, you might be talking with Jackson. This student said, I was wondering if you could offer some wisdom in the way of packing in as much as I can in the next few weeks. Without sounding like a sob story, my entire house has been sick for 2 months with COVID and various other preschool illnesses. So my time is in short supply. So this person's, I'm going to have you answer the mental piece of this, and then I'll answer the piece of, so functionally, what do I do over the next couple of weeks? So what do you say for the mental piece of the chaos of regular life intruding on this last precious bar study time?
Yeah. So if you've been studying and you're ready and you're in your review, it's okay. You've gotten everything in you need to know. It's all inside your head, and go handle life. You do not have to cram. You are in a good place and you are in review phase. Okay. That's where you're at. You won't know anything more in 2 weeks than today. The key is to relax so what you know can come out. So handle the chaos. I always like to say on my calls, if it can be handled quickly, handle it. If it can't be handled or something you can't handle, let it go. Take time for your family, take time for your life, but also schedule your review time. If you have small kids, you may have to suck it up a little bit and do your review time after they go to bed at night so it's quiet. Don't try to do both at the same time because you won't get good study time or good review time in, and you'll feel more frustrated. So again, you may have to do it an hour after the kids go to bed, but it's okay. You are ready, you're prepared, and there's no need to get frustrated right now. Just stay your course. You're absolutely fine.
Yeah, great. Thanks. That's really good advice. In terms of for the question about what do I do with getting through the material efficiently, then what I would say is as goes hand in hand with June, but be easy on yourself, right? We are not expecting you to get through every MBE question in the course, right? We're not expecting you to write every practice essay in the course. You will be fine. Do what you can do. And then when you feel comfortable and confident with the subject, move on. You don't have to, this is not a huge checklist of if I haven't accomplished everything on the list, then I'm doomed to failure. Give yourself grace, figure out what your weak points are and try to focus on those in the next couple weeks so that you can bring those up. And what I feel like I've been saying to a lot of students in the last week has been, keep in mind that this test is not, you don't have to attain perfection to you just have to get a passing score, which means there's a lot of room, right? When we tell you on a practice MBE, you're aiming for 65 out of 100 questions, correct? There's a lot of wiggle room in there for you to make a lot of mistakes. So don't beat yourself up if you're not hitting perfection or the level that you want. This isn't a 90% gets you an A, right? We just need passing. What's that old saying people used to say, C's get degrees. College, that this is the bar exams, that kind of a test of like all you have to do is pass, and no one cares or knows even in most jurisdictions what your score ultimately was if you did pass, just that you passed. Yeah, good job. All right, talking about these scores and with the MBEs, I got a few questions about people feeling like their scores are all over the board with these practice MBEs. So what do they do with that? I will say I have had a lot of discussions with students about this over the last week. So I will tell you, it's normal and okay if you feel like, wow, I thought I was doing really well on my MBE practice, and then I had one test that just did not go to plan, right? That is perfectly fine. It happens. What's funny is in investigating it with students, for most of them, there was a reason, right? So there was some external force that happened during the practice test that they were taking or right before it that actually threw them off their game. So you are okay if that happens to you. Shake it off and move forward and don't beat yourself up. All right. Next question is, we've been talking about MBEs. So next question is also about the MBEs. This student saying, I'm currently in the review process and getting bogged down by trying to complete all of the multiple choice and essay questions for each topic. So June and I just touched on this, that you do not need to complete everything. In fact, you can't. I don't know if I've ever known anyone I don't know how it would be possible. If you completed that much, you're probably overstudying and you're going to burn yourself out. Great. All right. Next, does anyone have any tips on navigating an essay when they read the question and aren't really sure what the question is getting at?
Yeah, for me, I think you start with this with conflict pairs, right? You start taking and saying to yourself, if I were really looking at this in the real world, I'd have party A that wants something and party B that wants something. What's the essence of their dispute or their conflict and start putting that together on paper. The conflict pairing approach really was designed to help you when you just didn't know what to do with a question. A lot of times we know, right? The examiners over the years have gotten much more specific about what the call of the question is. So you can almost set up your answer around the call of the question. In fact, I've been looking at all the July 2021 exams across the country. That's exactly what happened. There were no discuss all issue kinds of questions anywhere in the country that we dealt with. So I think you can be pretty specific. And then if you're hedging party A's argument, party B's argument, and you're paraphrasing what you think the law would be in support, then when you reach a conclusion, it may be right, may be wrong, but you at least are in the right ballpark and you're going to get some credit for that. So that's my approach to it. Do you do anything different?
No, I would just add that I am a firm believer that the essay questions are not trying to trick you. I think the MBEs are trying to trick you. I think they deliberately write them vague and difficult, especially the Florida multiple choice questions. But I believe that the essays, they give you, if they write a paragraph about something, it's a clue. It's helpful for you. There's something about those facts that are going to be helpful. So if you get lost, I think you need to use the facts to help work your way backwards to figure out, okay, why did they tell me that? What's important about that? Oh, of course, it's because that's the important factors that I need to know to determine that the business records exception applies. That's why they bothered to tell me about a filing cabinet with all these signed documents in it. I think there are clues in the essay fact pattern itself, if you get stuck, that you can use to help work your way backwards. So that's what I would suggest.
Okay.
Great. All right. With that, I think, Jackson, your timing was impeccable to come back because we're ready to talk about parole evidence. And man, I was ready to do it on my own, but glad that I get to do it with you instead.
All right, good. I'm going to turn off my camera here and I'm going to jump to a shared screen. So give me just 1 second. We'll get that up on the screen. Hopefully we'll be able to keep everything together. Megan, do you see the screen there? You know, it's not the study questions. It's the study questions that keep students awake, but it's the next subject for these that keep me awake. So I just want to say, that's me there looking and saying, what are we going to do next? But today, we're going to talk about, I think, a pretty important rule in contract law, and that's parole evidence. And we do get questions from time to time from students saying, how do you apply this rule? It seems pretty straightforward, but how does it apply in contracts questions? And that's what we want to look at today. And as we've been doing all along, what we did was to create a new mind map. If you have BarMaps, you will see this in your contract BarMap subject. It will be section 3 called Contract Content and Meaning. And then we expanded out the parole evidence rule so that what is here, and I know some of you have already gone in and started to work with that. Now, I know that you can't read it on the screen the way it is, so I'm going to break it down as we've been doing into some smaller pieces, but I am going to move rather quickly through it because I want to get to some questions and show you the application. As I said, it's contract content and meaning. That's the broad category. And then we want to look at parole evidence and how we interpret it. Now, the general rule of parole evidence is really pretty straightforward. When a contract is in writing and the parties intend the writing to be the complete and final expression of what their intent is, then this thing called the parole evidence rule will exclude any evidence which varies or contradicts the writing. Now, that idea of evidence that varies or contradicts the writing is really important because if it just supports the writing, then it's not parole evidence. And we have to know that it's prior to or it's contemporaneous with the signing of the contract, but parole evidence can be oral or written. So that's the general rule. If you understand that rule, I think you're going to be in pretty good shape. Now, as often happens, we have to define some of the terms. And when we think of a writing as a final expression of the agreement, we're going to use some terms you've probably seen before. Full integration, partial integration, merger clauses, memorandums, those are all ways of thinking of writings. And so if you're not clear on that, you want to spend some time and develop out your study in those areas. Now, as I looked at parole evidence questions, and Megan and I looked at several of them, one of the things that we found was that the examiners like to test exceptions. Would you agree, Megan? That's where their head is?
I think that's their head on all the essays and the MBEs in general, huh? They love those exceptions.
Yeah, exactly. So I want to just point out that in the mind map, we have the primary exceptions, and you should be aware of these. And very briefly, The exceptions would be subsequent oral agreements. That's an exception to the Parol Evidence Rule. It doesn't violate it. A defense to the contract of fraud or duress or mistake, not a violation of the Parol Evidence Rule. Big one is a condition precedent. If you have a condition precedent to the contract, that is not, and you introduce evidence of that, that's not a violation of parole evidence. And if there's ambiguity and it's based on custom and usage, that's not a violation. And something called a collateral agreement, which is different than a condition precedent. This is a separate agreement around a different matter that's tangentially related to our primary agreement. That can be proved by parole evidence. So you're not violating the rule with a collateral agreement. And if there are facts that are not in accord with the writing, then that's an exception as well. So if you're going to learn anything about parole evidence, learn those exceptions, because as I looked at the questions, just one after another, that's really where they like to be. And lots of wrong answers came out of the exceptions. All right, the other last piece you need to know, I think, about parole evidence is that there are some special rules if you're in the UCC. So if you're dealing with an agreement between merchants and it's under UCC, you've got some Article 2 exceptions and rules around parole evidence. The first thing you really need to know is that in the UCC, the intent of the parties really control. And so they're going to try and make parole evidence. It's not going to violate the parole evidence rule if you have this idea of being in agreement, if the parties are in agreement, or if there's evidence of intent. So the intent of the parties really controls whether or not we introduce parole evidence. And the second basic principle is that when parole evidence is used to explain or supplement terms in the UCC, then that is acceptable, but you can't contradict the writing. So no evidence that contradicts the writing is admissible. And so you see the actual definition there of how you can supplement or explain. So the UCC got some slightly different rules. Make sure you know those, but also make sure when you're looking at a question whether or not you're in the UCC. Tends to be a problem for people. All right, now, Megan, we ready to do a question? Okay, that was pretty good. I got through that pretty fast, didn't I? Okay, all right. So here's our first question. I'm going to read it for you, and then we'll talk about it. Employees Inc., a personnel placement agency in need of a new computer system, entered into a written agreement with CompuHelp, a supplier and installer of computer hardware and software, to supply and install a new system that's custom designed for employees. The total contract price of $50,000 was made payable at such time as the system was installed and operating, and the contract listed in detail the specs of all the hardware and software to be installed. 1 week prior to signing the agreement, the parties orally agreed that the agreement would not be binding on either party unless Consultant, a qualified computer expert hired by Employees Inc., approved the system. Upon review of the system, Consultant disapproved of it. Employees Inc. immediately notified CompuHelp and refused to permit CompuHelp to proceed with the installation. Now, the question is, in a suit by CompuHelp against Employees Inc. for breach of contract, a manager of Employees Inc. proposes to testify about the side agreement concerning Consultant. The trial judge should rule this testimony. So, Megan, what do we got here?
Yeah, so we have a valid contract between the two parties, and then we have this other side oral agreement. And then the question of if this manager can testify about this side oral agreement. So we have parole evidence.
Yeah. Okay. So it's going to be a binary problem. The trial judge is either going to rule the testimony admissible or inadmissible, right? So the first thing you want to do is, with that very quick introduction I gave you in the mind map, you want to think to yourself, does this sound like evidence that could be admitted or inadmissible? And remember, it's an oral agreement and it was about the consultant. So let's look at the answer choices. But remember, first place to start in selective intuition is just make your primary cut admissible or inadmissible. And if you've got a reason why, that's even better. We ready to move on?
Yep.
All right, here we go. Answer choice A says the trial judge should rule this testimony admissible because the oral agreement required approval by consultant. All right. Choice B says admissible because the evidence of the prior oral agreement shows that the writing was intended to take effect only if consultant approved of the system. So those are our two admissible choices. So if you thought that the testimony is admissible, which one of those is better? Now, inadmissible. Choice C. Inadmissible because the parole evidence rule bars evidence of a prior oral agreement, even if it is consistent with the terms of a partial integration. Ooh, we got a lot of buzzwords there, don't we? All right. And then D, inadmissible because the prior oral agreement contradicted the writing by making the parties' duties conditional. So we've got two admissible arguments and two inadmissible arguments. What do you do with that, Megan, as you're looking at that?
I think, just like you said, I would try and figure out first, like, intuitively do I feel like this manager should be allowed to testify about the side agreement or not? And hopefully I can have a reason come to mind. And what I want to always be aware of too with something like this is maybe there is, for instance, an exception that we just went through that pops into my head, but remember that you might be looking for the negative of it, or you might be looking for a different way of them saying it. So it's not always as straightforward of them saying admissible or inadmissible because of the word or the phrase that you saw on that exception, but it might be a roundabout way of them explaining the exception.
All right. So now if you are watching live, what we want you to do in the chat box is type in A, B, C, or D. Be brave. And if you want to explain why you think it, go ahead and type that in as well. You've had a minute here. Those are your answer choices. I don't think we have to show them the question again, do we?
No, we're good. We are getting a lot of answer choice B.
B as in boy. All right. Answer choice A is wrong. Admissible because the oral agreement required approval by consultant. This oral agreement actually is a condition precedent, and therefore evidence is not barred by the parole evidence rule. So A reaches the right result. It is admissible, but it's the wrong reason. What this choice seems to say is that the terms of the prior oral agreement would be construed as part of the agreement. That's not true. The parole evidence rule, as we just saw, bars the use of prior oral agreements. So it is going to be admissible. It's important information to have. The court would want to have it, but not because it required approval by the consultant. So if you said A, you were on the right track, but didn't quite get there. So let's look at B, which is our correct answer. The trial judge should rule this testimony admissible because the evidence of the prior oral agreement shows that the writing was intended to take effect only if consultant approved of the system. That is the definition of a condition precedent, isn't it?
Yeah. And so that's what I was saying, where sometimes it's hard because with selective intuition, we might say, oh, it's admissible because it's a condition precedent. But of course, none of the answer choices say it like that. So you have to always be aware of, is this saying what I thought just in a different way, which is what's happening here.
Yeah. This answer is simply the exception to the operation of the parole evidence rule. It allows oral evidence concerning a condition precedent to a written contract. So if you chose B, yay, you got it. Way to go. You understand that part of the parole evidence rule. Let's look at the two inadmissible answer choices quickly. Answer choice C said it's inadmissible because the parole evidence rule bars evidence of a prior oral agreement, even if it's consistent with the terms of a partial integration. Now, look, that is a seductive answer because look what it's got. Prior oral agreement, consistent, partial integration, feels like it should be good, but it's just a dead wrong statement, all right? The parole evidence rule bars evidence which is inconsistent, not consistent with the terms of the written contract. And that's especially true if it's a partial integration. So it could suck you in there, couldn't it?
Yeah, this is what I mean when I say I think MBE questions are written deliberately to trick you. I think sometimes they'll take buzzwords that you'll remember. Gosh, I remember parole evidence rule, partial integration, and consistent. Those are words that I associate with it, but you don't really remember what it means. Yeah. And they'll try to lure you in with these shiny words.
Yeah. And so it's really important to understand in that first general rule that we had that the parole evidence rule excludes evidence which varies or contradicts the writing. So it's that consistency, and you want to make sure that here it was inconsistent. And then answer choice D, I hope you picked this one. It said that it was making the prior oral agreement contradicted the writing by making the party's duty conditional. No, that wasn't what was happening at all. It was a condition precedent, and it didn't deal with or vary the terms of the contract itself. So if you chose that, you weren't actually following the fact pattern closely enough. And of course, there was no contradiction between the oral agreement and the writing. So answer choice D wasn't going to work. All right. Anything else we want to say about this question?
No, I think that's it. I think we have time to do one more if we're
all right.
quick.
All right, let's jump to it. This question we've shortened a little bit to the essence, but let's go ahead and do it. ABC agreed to perform an inspection and testing needed during construction by XYZ of a complex belt conveyor for an industrial plant. XYZ estimated completion in 4 months. During negotiations, the parties had agreed that if overtime became necessary, it should be added on a time-and-a-half basis. The contract, however, merely called for XYZ to pay ABC $8,000 in 4 monthly installments. And it recited that, quote, all prior agreements are merged herein, and this contract may be amended only in writing, close quote. Now the question, if ABC offered to introduce evidence that during negotiations for the written contract, XYZ had orally agreed that overtime should be added on a time-and-a-half basis, which of the following rules would provide the most support for its offer? Now, this is a tough kind of question because instead of having binary choices, we're actually going to get a series of rules and we got to figure out which one actually represents the rule most effectively. Is that the way you would read this, Megan?
You find these ones to be difficult, which would provide the most support. That means you might not love any of the 4 choices and you need to pick the best one. So just be aware of that this can throw people off, this kind of stuff. They're not saying which one is necessarily correct. They're saying which one is the most correct, which one has the best support. So even if you're like, I really don't love any of these, you've got to pick the lesser of the 4 evils, I guess.
There you go. All right, so let's look at the 4 evils. Here we go. If XYZ had to introduce evidence that during negotiations for the written contract, XYZ had orally agreed that overtime should be added on a time-and-a-half basis, which of the following rules would provide the most support for its offer? A says parole evidence of collateral agreements is admissible. Okay. Statement B says parole evidence of negotiations is admissible in aid of interpretation. Answer choice C says parole evidence is admissible to show an oral condition precedent to the existence of the contract. And then answer choice D says parole evidence is admissible to show practical construction. All right, now, how do we take those 4 answer choices and think about them? I want to make a couple of suggestions here. One thing is a strategic decision that you can make, and we don't normally say go in and analyze answer choices, but when you've got this kind of a problem, I think you almost have to do something. I look at answer choice B and D, and my first question is, what's the difference between them?
Yeah.
Aid of interpretation and practical construction. Do those things mean anything different to you, Megan?
No, that's exactly what I would do as well, is I would recognize that B and D are really saying the same thing, which means they're probably neither one could be correct.
Yeah, I just don't think they can be. And so by that process of elimination, now I'm down to statements A and C. And so what I really want to ask myself is, statement A says parole evidence of collateral agreements is admissible. Okay. And then statement C says parole evidence is admissible to show an oral condition precedent to the existence of the contract. And now I have to go back to the fact pattern, I think, in this situation. If we look at the fact pattern, is this an agreement precedent to the contract? Doesn't look like it to me. Does it to you?
No, definitely not.
No. So I think it's going to become pretty obvious where we want to go here. And so we'll get all of those out again. So go ahead, A, B, C, or D. No one should miss this question. Okay. We getting answers, Megan?
No, now you've scared them because you said no one should miss it. Yeah, we're getting some A's.
All right. Okay. Let's jump in. Answer choice A is the correct answer. Now, let's talk about why it is. A reasonable argument, I think, can be made that the agreement for the overtime is a collateral agreement, and the written contract was not totally integrated. It was partial integration. Having said that, ABC prevail on that theory? No way, right? Would you agree? Payment for overtime, that's really part of the pay that they get on the job. So that should have been included in the written contract. But this is an example, as you were saying, Megan, where A is the correct choice only because none of the other choices really work. They're not good answers, right?
Yeah, it's just the least of the 4 evils. And those are the worst kind of questions. They stink. People complain about them every year. I'm so sorry. We feel your pain, but also you have to be aware that there are a few of these kind of questions where you just have to hold your nose and pick the best of the options.
Yeah, and collateral agreements is one of those exceptions that we identified. So if you see a collateral agreement, parole evidence can be used to prove a collateral agreement. Let's look at the other choices. B said it's admissible in aid of interpretation, but the agreement about the price of the job wasn't something that had to be interpreted at all. And as we said, B and D, you can't find the difference between them, so they're probably both wrong. Let's look at answer choice C, which said parole evidence is admissible to show an oral condition precedent to the existence of a contract. That's true, but the overtime agreement was not a condition precedent. So again, that would just be a misreading of the fact pattern, and that's what I wanted to show you there. So that's what we've got on those. And look, man, I think we're like right there at that moment, aren't we? All right, let me stop that. We'll stop that and bring ourselves back. I hope that was helpful. I hope that we gave you a little bit of an idea of parole evidence. We've got another couple of questions that we did, and we'll include those in the explainer, the longer explainer video, but wanted to give you that explanation. We appreciate all the questions, great questions this week, and thanks to everybody. Megan, you and I will be doing lots of conferences the next 13, 14 days, and so we'll be right there and hanging in. I am going to take a couple hours off to watch the Rams and the Bengals and to moan the fact that my Saints aren't there. But in any event, have a great weekend, everybody. Good to see all of you. Thanks, June, for being with us. Thank you, Megan. And we will see you all next Wednesday. We'll do a wrap-up, final Q&A before the bar exam. All right. Take care, everyone.
Bye.
Bye-bye.
Thanks for listening and watching the Extra Mile podcast for bar exam takers at celebrationbarreview.com.